Welcome back to LexTalks, Legal Topics Simplified, your one-stop shop for navigating the world of law. We're here to break down these complex legal concepts, especially for all you Indian law students out there.
Yes, absolutely.
Today, we're going to be diving deep into protection from conviction for offenses, as outlined in Article 20 of the Indian Constitution.
Okay.
So this article is like your legal shield, protecting you from unfair prosecution. And trust me, you'll want to know about this.
It's essential knowledge for anyone navigating the Indian legal system.
Okay, so let's unpack this. To really appreciate Article 20, I think it helps to understand how the rights of those accused of offenses have evolved over time. So imagine a time when kings could just decide punishments on a whim, no rules, no fairness, just whatever the king wanted.
It's a far cry from the legal systems we have today, right?
Exactly. Thankfully, things started to shift with documents like the Magna Carta in 1215.
Yeah.
So it's a big deal because it limited the power of the monarchy and set the stage for fundamental rights like due process and fair trials, things that we now take for granted.
Yeah, the Magna Carta had a ripple effect globally. It influenced legal systems to recognize the rights of individuals facing accusations.
Exactly. And now fast forward to modern-day India. Article 20 of our Constitution acts as a safeguard against unfair prosecution.
Mm-hmm.
And it's got three key clauses that we're going to break down.
Okay. Think of it as a three-part safety net built into our legal system.
I like that, three-part safety net. So first up is Article 21, protection against ex post facto laws. Put simply, this means you can't be punished for an act that wasn't a crime when you did it. No retroactive punishment.
Right. So for instance, let's say a law is passed tomorrow, making it illegal to wear blue shirts.
Right.
Article 21 ensures that you wouldn't be punished for wearing one today.
Right. Makes total sense. But it's not just about hypothetical blue shirts, is it? There are real cases that demonstrate the application of this clause.
Absolutely. The case of Prahlad Krishnakaran v. the State of Bombay from 1951 is a great example.
Okay.
The court clarified that Article 21 specifically protects against retroactive punishment for criminal offenses, not for things like preventative detention.
Okay. So if someone is detained preventively based on a law that wasn't in place at the time of the alleged offense, Article 21 wouldn't apply.
Correct. There are other legal avenues to challenge preventative detention.
Okay, important distinction. Okay, moving on to Article 22, protection against double jeopardy. This one's pretty straightforward. You can't be punished twice for the same crime.
Right. It ensures that the state doesn't get multiple bites at the apple, so to speak.
Wow.
Once you've been punished for a crime, that's it.
Right, but here's where things get a bit nuanced, though,
Yeah.
right? The scope of this protection in India is narrower compared to some other countries.
That's right. In India, both the trial and the punishment need to have been completed for double jeopardy to apply.
Right.
If you were only tried but not yet punished, there's a possibility of facing another trial for the same offense under certain conditions.
Wow, that's really different from how it works in places like England or the U.S.
Yeah.
And there's a case that highlights this distinction, right?
Yes, O.P. Dahiya v. Union of India in 2003. The Supreme Court clarified that a retrial wouldn't be considered double jeopardy if the accused was neither convicted nor acquitted in the first trial.
Okay, so there are specific circumstances where retrial is allowed without violating Article 20. Interesting. Okay, now on to the third clause of Article 20, probably the one you've heard the most about.
It's definitely a popular one, especially in crime dramas.
Exactly.
Yeah.
So Article 23, protection against self-incrimination. You have the right to remain silent, meaning you can't be forced to testify against yourself.
Right. This protection prevents authorities from, coercing confessions or using forced testimony to secure a conviction. However,
That's true.
The key here is what constitutes compulsion.
Right.
It must involve physical force, not just mental pressure or skillful interrogation.
Okay, so simply feeling intimidated during questioning
Yeah.
wouldn't be enough to invoke this protection.
Right.
There has to be actual physical force used to extract a statement.
Precisely. The courts have have examined various situations to determine what qualifies as compulsion under Article 23.
Huh.
For instance, in state of Bombay, Bikathikali Wagadan Ors, the Supreme Court ruled that simply being in police custody doesn't automatically imply compulsion.
Okay, so just being in a police station doesn't mean everything you say is considered coerced. But what about situations where there's clear physical force?
Well, the case of Ghazi v. State of Uttar Pradesh provides a contrasting example.
Okay.
In this case, the court ruled that police brutality absolutely constitutes compulsion. Any statement obtained through such means would be inadmissible as evidence.
Makes sense. Physical force is a clear violation. Now, what about situations where someone might unintentionally reveal incriminating information? Like they don't even realize they're saying something that could be used against them.
Yeah, that's addressed in Yusuf Ali v. State of Maharashtra.
Mm.
Let's say the police are secretly recording your conversation,
Okay.
and you unknowingly confess to something. Since you weren't aware of being recorded or pressured to speak,
Oh, yeah.
the court found there's no compulsion in that scenario.
Oh, that's a bit tricky. Imagine thinking you're having a private conversation and it ends up being used against you in court.
It highlights the complexity of these legal principles. The case of R.M. Alkani v. State of Maharashtra further explores this complexity with recorded phone calls.
Right.
The Supreme Court determined that if the police record a phone call with the consent of one party, the conversation is admissible as evidence.
Okay, so the other party's consent makes it okay, even if the person on the other end of the line is unknowingly incriminating themselves.
That's the court's interpretation. The focus is on whether there was direct pressure on the person making the incriminating statements.
Okay, I'm starting to see how nuanced this can get. But what if someone willingly offers incriminating evidence against themselves? Does Article 23 still apply?
This is where the concept of waiver comes in.
Okay.
In Lakshmi Pacharia v. State of Maharashtra, the Supreme Court stated that Article 23 is essentially a privilege that can be waived.
Yeah.
If you choose to volunteer incriminating information, you're essentially choosing not to exercise that protection.
So it's not an absolute shield. There are situations where it might not apply. It seems like the courts have to carefully consider the context of each case to see if someone's right against self-incrimination has truly been violated.
Exactly. The circumstances surrounding the statement are crucial in determining whether Article 23 comes into play.
Okay. This has been incredibly helpful in understanding Article 20. Before we move on, are there any other related legal concepts that might come up in exams or in practice, like things that students should be aware of that kind of tie into this?
Yeah, there are a couple of important ones.
Okay.
Firstly, res judicata, which essentially means a matter judged.
Okay.
It prevents the same issue from being relitigated once it's been decided by a court.
So you can't keep bringing the same issue back to court over and over again.
Right. Section 11 of the Code of Civil Procedure codifies this principle, ensuring finality in legal proceeding.
Makes sense. Okay. What's the other concept?
The use of judgments as evidence, which is covered by sections 35 and 36 of the Bharatiya Saksha Adhinyam 2023, formerly sections 41 and 42 of the Evidence Act 1872.
Okay. So how does that work in practice? Like how are judgments used as evidence?
Well, section 35 states that judgments in specific cases like probate, matrimonial, or insolvency matters can be conclusive proof.
Okay.
Meaning they definitively settle the matter. For instance, a judgment granting a divorce would be conclusive proof that the marriage has legally ended.
Got it. That judgment is the final word on that issue.
Yeah. However, section 36 clarifies that judgments in other cases are only relevant but not conclusive. This is especially true for matters of a public nature.
Okay, can you give an example of that, like a specific scenario where that would apply?
Let's say there's a dispute about a public right of way through a property.
Okay.
If a previous judgment in a similar case found that such a right of way existed, that judgment would be considered relevant in the current case. However, it wouldn't be the deciding factor.
Ah,
Okay.
so the court would consider the previous judgment, but could reach a different conclusion based on the specifics of the current case.
Precisely. Understanding these nuances and how judgments are used as evidence is important.
Okay, that helps clear things up. Now, how does India's commitment to these rights under Article 20 align with international standards? Like, are we in line with what other countries are doing in this area?
Well, India is a signatory to several key international agreements that reflect the principles enshrined in Article 20. For example, the International Covenant on Civil and Political Rights, or ICCPR, covers things like humane treatment of detainees, the right to a fair trial, and protection against self-incrimination and double jeopardy.
Right. So these international agreements basically uphold the same rights that are protected under Article 20.
Exactly.
Right.
And then there's the Universal Declaration of Human Rights, or UDHR, another foundational document for human rights globally.
Right.
It includes articles on protection from arbitrary arrest, the right to a fair trial, and the presumption of innocence until proven guilty. Principles that are also central to Article 20.
Right. So
Yeah.
India's stance on these fundamental rights is in line with global standards. That's good to know. Now, before we wrap up this part of our deep dive, I want to leave our listeners with some questions to ponder.
Okay.
So, in today's world, how do we balance effective investigation with protecting individual rights, especially with all the technological advancements that we're seeing?
It's a crucial question.
Right.
For example, does the right to remain silent only apply once someone has been formally accused, or does it extend to someone who's merely a suspect in an investigation?
That's a good one. And does protection against self-incrimination only apply to current accusations,
Right.
or could it also shield someone from potential future accusations?
These are areas where the law is constantly evolving, and court decisions are shaping the boundaries of these rights.
So we're not just talking about theoretical concepts here.
Yeah.
These are real world issues being debated in courts right now.
Absolutely. And then there's the whole question of when the right to remain silent applies. Is it just in court, or does it extend to interactions with law enforcement during an investigation? What about the limits of police questioning under Section 112 of the Criminal Procedure Code?
There's definitely a delicate balance to strike between giving law enforcement the tools they need to investigate, and making sure individual rights aren't trampled in the process.
You've hit the nail on the head. It's a fascinating area of legal discussion. Stay tuned for part 2, where we'll delve into some landmark cases that really put Article 20 to the test in the modern age.
Awesome. I can't wait.
Welcome back to LexTalks. In this part of our deep dive, we're going to explore some landmark cases that have really pushed the boundaries of Article 20.
I'm ready to dive in. Let's start with the case of Selvi, state of Karnataka.
No.
It deals with some pretty controversial investigative techniques.
Yeah, this case from 2010 really grapples with the use of neuroscientific methods like brain mapping and narcoanalysis in criminal investigations.
Okay.
It's the kind of stuff you might see in a movie, but these are real techniques that raise serious questions about individual rights.
Brain mapping and narcoanalysis. What exactly are we talking about here?
Well, narcoanalysis involves injecting a suspect with a drug, sodium pentothal, that puts them in a sort of twilight state.
Okay.
The idea is that in this state, they're more likely to reveal hidden truths. It's kind of like a truth serum, though its reliability is highly debated.
I can see why that would be controversial. What about brain mapping?
Brain mapping, also known as brain electrical activation profile, or BEAP, measures a person's brain activity in response to certain stimuli.
Right. Investigators use it to see if a suspect recognizes information related to a crime.
It all sounds very, very futuristic. But both of these techniques seem to raise concerns about a person's right against self-incrimination, right? I mean,
Right.
if you're under the influence of a drug, or your brainwaves are being analyzed, can you really be said to be giving information voluntarily?
You've hit on the core issue in Salvia Sita Karnataka.
Okay.
The Supreme Court ultimately ruled that these methods, when used involuntarily, are unconstitutional.
Yeah.
Forcing someone to undergo these procedures and then using the results against them in court violates their fundamental rights, including their right against self-incrimination.
That makes sense. It's like forcing someone to testify against themselves. But what about polygraph tests? Did the court's decision in Selvi cover those too?
The court's ruling on polygraph tests was a bit more nuanced. While they acknowledged that polygraph tests can raise self-incrimination concerns, they didn't outright ban them.
Okay.
Instead, they said the results of a polygraph test are generally inadmissible as evidence unless the person being tested consents to its use.
So consent is key here. If someone willingly agrees to take a polygraph test, knowing how it works and that the results could be used against them, it's seen as a waiver of their right against self-incrimination.
Exactly. The court stressed that a person needs to be fully informed about the nature of these tests, their potential consequences, and their right to refuse before they can validly consent.
So it's not enough to just get someone to say yes to a polygraph. They need to understand what they're getting into. That's a pretty important distinction.
It is, and this emphasis on informed consent reflects a broader trend in how the courts are interpreting Article 20, especially when it comes to new technologies and investigative techniques.
Yeah, it seems like Selvi v. State of Karnataka drew a line in the sand. What other landmark cases have further shaped our understanding of Article 20?
Well, let's move on to Tofan Singh v. State of Tamil Nadu.
Okay.
This case from 2020 delves into the admissibility of confessions in drug offense cases. It really gets into the nitty-gritty of how Article 20 interacts with specific laws like the Narcotic Drugs and Psychotropic Substances Act or NDPS Act.
Drug laws can be pretty complicated. What was the main issue in Tofan Singh?
The core issue revolved around confessions recorded under Section 67 of the NDPS Act. This section gives officers the power to question anyone suspected of being involved in drug-related offenses. However, in this case, the appellant, Tofan Singh, later retracted his confession, claiming it was coerced.
So the question became whether a confession obtained under Section 67 of the NDPS Act could have used against him if he claimed it wasn't given voluntarily.
Precisely. It's a clash between the specific provisions of the NDPS Act and the broader protections of the Constitution, particularly the right against self-incrimination.
Right. Okay. So what did the Supreme Court decide?
The court made a significant ruling stating that confessions recorded under Section 67 of the NDPS Act are not admissible as evidence if they violate a person's fundamental rights. They emphasize that even though the NDPS Act grants officers certain powers, those powers cannot override an individual's constitutional protections.
Okay. So it's a powerful reminder that constitutional rights are paramount even in specialized areas of law like drug offenses. You can't just ignore those rights because it's a drug case.
Absolutely. The court went even further in Tofan Singh, clarifying that officers acting under the NDPS Act are still considered police officers for the purposes of the Evidence Act.
Okay.
This means any exceptions that might exist for certain officers under other laws wouldn't apply in NDPS cases.
And why is that distinction important?
The court argued that making exceptions for officers in specific penal statutes could weaken the principles of equality, privacy, and the right against self-incrimination guaranteed by Articles 14, 21, and 23 of the Constitution.
Right.
It's all about ensuring those constitutional safeguards are applied consistently across the board.
Yeah. It sounds like the court was really trying to prevent any loopholes that could undermine the protection of individual rights.
Yes, and Tofan Singh really highlights how the courts are constantly working to balance the need for effective law enforcement with the need to safeguard individual rights, especially in the context of drug offenses.
These cases are fascinating. They really show how Article 20 is constantly being tested and reinterpreted in light of new challenges and advancements. It makes you wonder what what future cases might bring, especially as technology continues to evolve at such a rapid pace.
Exactly. New technologies and investigative methods are constantly emerging, and it's gonna be interesting to see how the courts grapple with applying Article 20 in those contexts.
Yeah. These are definitely issues that will keep legal scholars and the courts busy for a long time to come. But for now, let's take a break. We'll be back with part 3, where we'll examine some of the contemporary challenges and unanswered questions surrounding Article 20 in our increasingly digital age. Welcome back to LexTalks. We've covered a lot of ground in our deep dive into Article 20, but as we've seen, the law is a living thing.
Yeah.
It's constantly evolving to meet new challenges. And in this final part, we're going to explore some of the contemporary questions surrounding Article 20 in our increasingly digital age.
It is fascinating to think about how a document written decades ago is still so relevant today, especially when you consider the rapid pace of technological change. New technologies are constantly popping up, and they often raise new legal questions.
Exactly. So what are some of the big questions on the horizon when it comes to Article 20 and the digital world?
One area that's generating a lot of discussion is the scope of the right to remain silent.
Yeah.
We know it's a core element of protection against self-incrimination, but how does that play out when someone is merely a suspect in an investigation, not yet formally accused?
That's a tricky one. If the police are questioning someone, do they have to answer every question, even if those answers could potentially incriminate them later on?
That's a question the courts are grappling with. There's also debate about whether the right to remain silent applies only in court, or if it extends to interactions with law enforcement during an investigation.
So could you refuse to answer questions during a police interrogation based on your right to remain silent?
It's a gray area.
Yeah.
Legal experts have differing opinions. Some argue that compelling someone to answer questions during an investigation could violate their right against self-incrimination.
Okay.
Others say that allowing suspects to remain completely silent would hinder effective investigation.
It seems like finding the right balance is key.
Yeah.
And I imagine technology adds another layer of complexity in all of this.
Absolutely. Think about the sheer volume of data that's constantly being generated through our phones, computers, and online activities.
It's a bit overwhelming, honestly.
Yeah.
Could all that data be used against us in a criminal investigation, even if we haven't been formally accused of anything?
That's a valid concern. The application of Article 20's protection against self-incrimination in the digital realm is something that's still being explored and debated.
It makes you think twice about every email you send and every website you visit.
Yeah.
What about the use of things like artificial intelligence and facial recognition in law enforcement? How do those technologies fit into the picture?
That's another area where the intersection of technology and individual rights is crucial. AI is being used to analyze data and identify patterns that might indicate criminal activity. Facial recognition is increasingly used for surveillance and identification purposes.
It's a bit like those science fiction movies where computers can predict crimes before they happen. But where do our individual rights fit into all of that?
That's the question, isn't it? Could these technologies lead to false accusations or erode our privacy in ways we haven't even anticipated? As these technologies advance, it's vital that the legal system keeps pace to ensure that our fundamental rights aren't compromised.
It seems like these are questions that will keep lawyers and judges busy for years to come.
Absolutely. The interpretation of Article 20 will need to adapt as technology continues to evolve. It's a dynamic process, and that's what makes this area of law so interesting.
I agree. It's both exciting and challenging to think about how these legal principles will be applied in the future. So for all you aspiring lawyers out there, these are the kinds of issues you might be grappling with as you embark on your legal careers.
Who knows? Maybe one of you listening will be the one to argue a groundbreaking case before the Supreme Court, shaping how Article 20 is interpreted in our digital age.
That's an inspiring thought. We've reached the end of our deep dive into Article 20 of the Indian Constitution. We've explored its historical roots, analyzed landmark cases, and pondered the challenges it faces in the modern world. Hopefully you gained a deeper understanding of this vital article and its significance in protecting individual rights.
And if you're feeling inspired to learn more, we encourage you to do your own research, read legal opinions, and engage in discussions about these important issues. Article 20 is a cornerstone of our legal system, and understanding its nuances is essential for anyone navigating the complexities of Indian law.
Absolutely. Thank you for listening to LexTalks. Follow, subscribe, and stay notified for future episodes.